s'asseoir.
Good afternoon. Would the court officer please call the case?
Good afternoon, Mr. President. The situation in Darfur, Sudan, in the case of the prosecutor versus Ali Muhammad Ali Abd-Al-Rahman Ali Kushaid, case reference ICC 0205-0120, and we're in open session.
Thank you. I'm Judge Piotr Kowmański, presiding in this appeal arising from the case of the prosecutor against Ali Muhammad Ali Abd-Al-Rahman. My fellow judges in this appeal are Judge Luz del Carmen Ibanez Carranza, Judge Perrin de Brichambault, Judge Salome Balongi-Bosa, and Judge Gocha Lord Kipanidze. May I ask the parties to introduce themselves for the record, please, starting with the defense. Mr. Lauci.
Bon après-midi, Monsieur le Président.
Good afternoon, Mr. President. For the defense of Mr. Abd-Al-Rahman, assisting at a distance, but in the courtroom we have Mr. Ahmed Issa, who is the case manager, Mr. Abe Kalb, who is assistant reviewer of evidence, and Mr. Mohamed Al-Rahi, who is also in charge of analyzing evidence, and I am lead counsel, Mr. Cyril Lauci.
Thank you, Mr. Lauci. In the office of the prosecutor, please.
Good afternoon, Your Honors. The office of the prosecutor is represented by Mr. Edward Jeremy and myself, Reinhold Kalmetzer.
Thank you, Mr. Kalmetzer. Legal representation for victims, please.
Yes, good afternoon, Mr. President. Nathalie von Wistinghausen. I'm appearing on behalf of the Common Legal Representative of Victims, and our case manager, Idris Anbari, is in the courtroom. Thank you very much.
Thank you. Thank you very much, Madame Wistinghausen. Thank you all. For the record, I note that Mr. Abd-Al-Rahman participates from the remote location. Today, the Appeals Chamber will deliver its judgment in the appeal of Mr. Abd-Al-Rahman against the decision of the Trial Chamber 1, entitled Decision on the Review of Detention. This is non-authoritative summary of the Appeals Chamber's written judgment in the appeal. The written judgment will be notified after this hearing. I will now briefly explain the context of this appeal. Following the issuance of an arrest warrant on 9th of June 2020, Mr. Abd-Al-Rahman surrendered himself and was transferred to the detention center of the court. On 14th August 2020, Pre-Trial Chamber 2 issued a decision under Article 60, subparagraph 2 of the statute finding grounds to detain Mr. Abd-Al-Rahman pending trial due to the risk that Mr. Abd-Al-Rahman or his supporters may interfere with the victims or potential witnesses in the proceedings. The pre-trial chamber reviewed its decision on detention December of that year, and then again in April and July of 2021. The chamber found that the reasons for Mr. Abd-Al-Rahman's detention had not changed in favor of his release pending trial. On 9th July 2021, the pre-trial chamber confirmed the charges against Mr. Abd-Al-Rahman. After the case was transferred to the trial chamber, the chamber held a hearing on the review of detention. On 1st November 2021, the trial chamber issued its decision finding that there were no changed circumstances within the meaning of Article 60, subparagraph 3 of the statute that would warrant interim release, and the trial chamber decided to maintain the detention of Mr. Abd-Al-Rahman. I will call this the impugned decision. The defense appealed the impugned decision, raising 4 grounds of appeal. First, the defense alleges that the trial chamber committed 2 distinct factual errors in taking into account that the proceedings had advanced beyond the confirmation of charges. Second, the defense alleges that the trial chambers committed an error of law in reversing the principle of pretrial detention in an exception, and liberty is the rule. Third, the defense alleges that the trial chamber committed factual errors in relation to its findings about the potential for witnesses' interference. Fourth, the defense alleges that the failure to respect of Mr. Abd-Al-Rahman's right to family visitation in the detention center renders his detention unlawful. Ultimately, the defense seeks interim release for Mr. Abd-Al-Rahman. I will now address the merits of the appeal. Under the first ground of appeal, the defense alleges that the trial chamber failed to consider that the accused had surrendered himself to the court, even though in doing so he faced punishment in Sudan. The defense also alleges that the trial chamber failed to consider that the risk the accused faces in Sudan would deter him from trying to abscond today. Contrary to the defense's position, the appeal chamber considers that the trial chamber was well aware of the circumstances of Mr. Abd-Al-Rahman's surrender. Indeed, the trial chamber determined that the defense's submission about the risk Mr. Abd-Al-Rahman faced in Sudan resulting from his decision to voluntarily surrender were irrelevant. The appeal chamber notes that the fact that the suspect surrendered himself voluntarily to the court can be understood as an indication of his willingness to cooperate with the court in its proceedings. However, in this case, the appeal chamber notes that the prosecutor had identified a number of events that suggest that there could be a concrete risk that if the accused were granted interim release, he or his supporters might interfere with the court's proceedings. Therefore, the appeal chamber is not persuaded that the trial chamber assigned insufficient weight to the circumstances of Mr. Abd-Rahman's voluntary surrender. As to the defense argument about the difficulties that Mr. Abd-Al-Rahman may face should he return to Sudan, the appeal chamber observes that the defense only advances speculative arguments about how these risks may affect Mr. Abd-Al-Rahman's motivation to abscond. Nor does the defense explain how these risks may affect the primary reason for Mr. Abd-Al-Rahman's continued detention under Article 58, subparagraph 1b(2) of the statute. Therefore, the appeal chamber finds no error, and the first ground of appeal is rejected. Under the second ground of appeal, the defense submits that the consideration of the confirmation of charges as a factor favoring detention pending trial would lead to the conclusion that detention is justified in all cases that have advanced past the trial stage. This, according to the defense, would have the effect of reversing the presumption that detention is the exception to the rule and that the right to liberty must be respected. The appeal chamber observes that human rights jurisprudence holds that individual freedom as a basic guarantee constitutes the rule in all cases, and any deprivation thereof must be an exception. In praxis, this means that the burden of proof falls on the prosecuting authority to demonstrate the existence of reasons to maintain the custody of an individual awaiting trial. The Appeals Chamber notes, however, that the presumption of liberty does not mean that the detention cannot be imposed where there exists a legal basis for doing so. Although the starting point in all cases is that the person who is subject to criminal proceedings shall enjoy the right to liberty, he or she may be deprived of that liberty as prescribed by law in a manner that is strictly necessary under the circumstances. Contrary to the defense's position, the Chamber's assessment of whether a person's right to liberty is respected must be individualized, looking at the presence of concrete risks weighing against the presumption of interim release on a case-by-case basis. Moreover, the right of physical liberty as defined in human rights law is not violated where a chamber has determined that, in addition to the fulfillment of the requirements in Article 58, subparagraph 1a of the statute, pretrial detention is necessary to prevent the risks enumerated in Article 58, subparagraph 1b of the statute. In this regard, the confirmation of charges may, in the opinion of Chamber, be a factor when considering whether the risk that an accused may evade justice continues to exist. Importantly, this finding does not on its own displace the general rule concerning the exceptionality of pretrial detention. Therefore, the Appeals Chamber is not persuaded by the defense's argument that the trial chamber committed an error of law in reversing the principle that liberty is the rule and detention is the exception. For these reasons, the Appeals Chamber rejects the defense's second ground of appeal. Under the third ground of appeal, the defense alleges that the trial chamber failed to consider that the accused was on the run at the time that the evidence of the prosecutor was recorded, and therefore he was incapable of issuing threats at the time. In support of this argument, the defense emphasized that there was a warrant for his arrest at the relevant time in Sudan, and there is new evidence demonstrating that he was on the run. Moreover, the defense argues that the trial chamber failed to appreciate that the video disclosed by the prosecutor contradicts the prosecutor's other evidence. The Appeals Chamber recalls that the review of detention conducted pursuant to Article 60, paragraph 3 of the statute is an opportunity for the relevant chamber to modify the original ruling on detention if it is satisfied that changed circumstances require. Here, the Appeals Chamber is not persuaded that the trial chamber erred in failing to conclude that the information that the defense refers to lead inevitably to the conclusion that Mr. Abd-Al-Rahman was on the run and therefore incapable to engaging in the acts alleged. Moreover, the potential cause for concern in January 2020 resulting from the warrant of arrest issued against Mr. Abd-Al-Rahman is a factor that was known when Pretrial Chamber 2 made its original finding about the impugned evidence of the prosecutor. As this is not a new fact constituting a change in circumstances, it was no incumbent upon the trial chamber to take this argument into account in the impugned decision. Therefore, the defense argument in this regard is rejected. Regarding the video evidence question, the appeals chamber notes that the defense made similar arguments about the content of this video and its negative impact on the probative value of the prosecutor's evidence before the trial chamber. The trial chamber concluded that, contrary to the defense position, that the video was capable of lending support to the prosecution's submissions that the accused, if granted conditional release, presents a potential or actual risk to witnesses. On appeal, the defense merely disagrees with this conclusion without indicating how the trial chamber weighed its submissions improperly, nor how the chamber's ultimate conclusion was unreasonable. The appeals chamber further considers that even if arguendo the press article relied upon by the prosecutor is itself insufficient, this was not the only evidence indicating the potential for witness interference. Therefore, the appeals chamber finds no error, and it rejects the third ground of appeal. Finally, under the fourth ground of appeal, the appeals chamber recalls that the court has a positive obligation to render the right to family visits effective for persons in detention center. However, as argued by the prosecutor, the court's regulatory framework governing detention matters provides an avenue for a detained person to secure his or her visitation rights. This avenue is separate from the procedure for the review of detention in Article 60, paragraph 3 of the statute. In particular, under the applicable regulations, the detained person is entitled to receive visits and to arrange for such visit upon application to the registrar. A detained person might make a complaint against any matter concerning his or her detention at any time to the chief cast at the office of the registrar, as the case may be. Judicial review of a decision of the registrar on the detention matter is taken up by the presidency. The appeals chamber notes that the defense has already seized the registry of the consultative process concerning Mr. Abd-Al-Rahman's visitation rights while in detention. This consultation is ongoing. Accordingly, the appeals chamber finds that the trial chamber did not err in rejecting the defense's argument that Mr. Abd-Al-Rahman's right to family visit was inoperative. Thus, the appeals chamber rejects the defense for the ground of appeal. Moreover, the appeals chamber recalls that both pre-trial chamber 2 and the presidency have warned the defense in this case against bringing parallel proceedings that are duplicate in nature. The appeals chamber finds inappropriate to write it here that such a practice is wasteful of this court's limited resources, and it should not continue. For these reasons, and for the reasons stated more fully in the written judgment, the appeals chamber unanimously rejects the appeal and confirms the appeal impugned decision maintaining Mr. Abd-Al-Rahman's detention. This brings us to the end of the summary of the appeals chamber's judgment. I would like to thank the court reporters, interpreters, and other register staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise, veuillez vous lever.